Allen.
Good morning. In this case, the appellant was convicted of aggravated indecent assault stemming from an incident that occurred in 2004. Prior to trial, the appellant moved to dismiss the charges, claiming that the prosecution had granted him immunity from criminal liability. The motion was denied. During trial, the Commonwealth introduced 5 witnesses under evidentiary rule 404B to testify regarding their accusations of sexual assault against the appellant for purposes of establishing appellant's common scheme or plan. The issues before the court are whether, 1, the testimony of the 5 witnesses regarding their respective accusations was admissible evidence under Rule 404B, and secondly, whether there was a binding agreement between appellant and the Montgomery County District Attorney that would result in immunity from criminal prosecution. With that, we'll proceed with the appellant.
Good morning, and may it please the court. In our system of justice, a defendant must be tried for what he did and not who he is. And yet the prosecution has made no secret of the fact that it intended to indict Mr. Cosby's entire life. After failing to secure a conviction after Mr. Cosby's first trial, the prosecution shifted strategy, laying waste to the presumption of innocence and telling the jury that Mr. Cosby's claim of defense could not be believed because, quote, he had done this so many times before. The prosecution forced Mr. Cosby to defend not only the charged offense, but 5 mini trials and vague accusations from countless Jane Does dating back to the 1970s. And while the public and the media were free to judge Mr. Cosby's guilt based on those factors, his criminal jury was not. And perhaps a limiting instruction served its purpose at Mr. Cosby's first trial, but there can be no confidence that it did its job at the second, where the jury was bombarded with prior bad act evidence. Indeed, half of the prosecution witnesses testified in connection with uncharged 404B allegations. Some of the allegations, the most damning ones, came from a deposition that should not have been admitted in the first instance on account of an agreement with the Montgomery County District Attorney not to prosecute Mr. Cosby, a promise on which he relied to his grave detriment.
They both from the Montgomery County did.
As argued in our briefs, none of the prior bad act evidence served a legitimate non-propensity purpose. But that aside, consensus surely must be reached that Mr. Cosby suffered unquantifiable prejudice where the PBA evidence or the prior bad act evidence overwhelmed his second trial, converting it from a trial on a single offense to a trial of his character. And with that, I would entertain any questions from the court.
Great opening statement, Jennifer. This is Bill Cosby's counselor, and Jennifer did a great job opening up, with her opening argument, letting them know from A to Z what they are asking for. And that was great. So I think Jennifer did a great job, on explaining to them what they want. And also she was ready for the judge's questions as well. She was well prepared. So I'm going to move on to the next one. So I'm going to say bravo to you, Jennifer.
Counsel, this is Counsel Justice Doherty speaking. Let me just zero in on the civil deposition. Even taking into consideration and finding is true that he, Mr. Cosby, your client, did not believe that he was to be prosecuted for the events involving Ms. Constantine. Tell me, when confronted with a question plausibly implicating criminal conduct, in any deposition, an individual has an affirmative duty to invoke their Fifth Amendment regarding other issues or potential other criminal conduct. Why was that not done by counsel for Mr. Cosby and Mr. Cosby himself?
Justice Doherty, his question was like the Fifth Amendment, like, okay, why he didn't do the plead the fifth. Just like Jim Dare Greasy. Jim Dare Greasy. I'm sorry, Jim Dare Gaddis. He plead the fifth. And I was like, okay, damn, Jim, you plead the fifth just to protect your sources, so you can have some stuff to write, some articles, to have some great articles. I don't want to give up my sources, so I'm going to plead the fifth because I do not care about these black women. But he's out here in the public saying that he care about the black women. They use this statement that they don't care about the black women. But if Jim Dare Gaddis cared about the black woman, he would have testified. He wouldn't have pleaded the fifth. That's an example of pleading the fifth, you guys. And see, Jim Dare Gaddis, he didn't want, he only write about Robert. That's his occupation, you guys. Just to write about Robert, RKelly. That's his livelihood to write about him. So he plead the fifth because I do not want to up these people that's in Robert's camp, that's giving me all the tea and adding a little lies to it as well. So, I'm going to plead the fifth, but I'm going to, I need to get back out there into that light. I need to get back in the spotlight because I'm dying out. Because, Robert, he's chilling and minding his own business. So, he done laid off all my sources and stuff. So now I have to use this like, I don't care. They don't care about the black women. I don't even care about the black women. Because, see, I plead the fifth. So I wasn't thinking about no justice. I was only thinking about, my livelihood, because this is my occupation, running behind the brand RKelly. You feel me?
Linked to the willingness to give a civil deposition, which we know this in part from looking at the press release, which demonstrated that not only did the district attorney at the time, Bruce Castor, decline to prosecute, but he mentions in the press release that there was going to be ongoing civil litigation. So, and you also can look at Mr. Schmidt's testimony, who's testified that it was our understanding, it was our belief that the promise not to prosecute would be honored so long as Mr. Cosby agreed to sit for this deposition and give testimony and not invoke his Fifth Amendment right, which he did, again, to his detriment. I think the fact that Mr. Cosby actually answered questions for 4 days, and I think it speaks to the court's point, that this is evidence in and of itself that he relied on this representation. No one would sit for a deposition and not invoke their Fifth Amendment right, guilty or innocent, if there was the possibility of criminal prosecution looming over your head. So the fact that he did leads to the only reasonable inference that he believed that in order to not be prosecuted, this was part of the agreement that he complied with. And as a result, to the extent that the prosecution wanted to use the deposition testimony, once they decided to prosecute him, that deposition testimony should have been off the table at a minimum.
Counsel, Justice Baer, at the first trial, and I don't think it's in our record, but it is properly before us, was there any prior bad act testimony?
There was one prior bad act witness who testified at the first trial, correct.
And of course, you didn't take an appeal because that was not a conviction.
That's right, Your Honor.
I understand your argument. I tend to agree that this evidence was extraordinarily prejudicial to your client. But there's a trial court discretion component here. In your view, if the trial court had allowed one again, would that have been an abuse of discretion? Or if the trial court allowed two? And where do we as an appellate court draw a line between abuse of discretion and a discretionary call, which perhaps we would have not made, but which was not powerful, we don't have the power to overrule?
Yes, understood, Your Honor. Our position is the trial court abused its discretion for two reasons. One, because not even one prior bad act witness served a non-propensity purpose, but also because the admission of 5 prior bad act witnesses was unduly prejudicial to the point that no limiting instruction could have cured it, and that these 5 discrete allegations from 15 to 22 years ago had such minimal probative value as compared to the danger of unfair prejudice that it seems clear that the court did not exercise discretion in allowing 5. So it's twofold. Our position is that there was no theory of admissibility that was for a non-propensity purpose. But even if this court were to disagree with that, at the end of the day, 5 witnesses, plus all of this vague testimony about quaaludes and Jane Does that were just exploited to the hilt during the closing arguments, that frankly were just contorted from the deposition testimony in the first place, put Mr. Cosby in a position where he had no shot. The presumption of innocence just didn't exist for him at that point. And so I think the court abused its discretion in both of those ways.
Thank you.
Sounds very familiar, doesn't it? Court abuse, presumptions of innocence, and prior bad act character witnesses that we have going on here. Also dealing with the Robert Sylvester Kelly's case, we have a Lisa Van Allen, we have a Geronda Johnson Pace. There is something in the past, an old trial that he was found innocent, and so they're bringing back Landfair family. So I feel even with the DA in New York for Robert's case, they are actually abusing the system, the court system, even not giving out the evidence and, discovery. They're not giving Robert's counselor this discovery. They're trying to wait till the last minute. So to me, it's just like abuse of power. And so hopefully Bill wins the case, and that we can open a door to look into how things are handled in the courts. So let's continue on to the next statement.
Counsel, this is Justice Donahue.
Good morning.
Good morning. Since you are not going to have time for rebuttal,
Yes.
I would like you to, for me, spend a little bit of time talking about why the evidence that was offered through these prior bad act witnesses did not go to establish a common plan or scheme or a signature crime, which is what I understand their reported use was.
Yes, Your Honor. So at the outset, I would say the common plan is an inapt theory of admissibility here for 2 reasons. One, because the prior bad act evidence was not part of a single overarching plan, which I think the prosecution concedes. It also was inapt because identity was not a disputed fact in this case. And the overwhelming authority from this Commonwealth and across the country is that signature-like prior bad acts, also known as modus operandi evidence, is relevant to prove identity. In fact, the test in this Commonwealth is that it must be so nearly identical to be the handiwork of the same perpetrator. But when identity is not in dispute, the evidence simply registers with the jury as propensity evidence. To put it very simply, where identity is a dispute, a modus operandi may be perfectly proper. Where identity is not in dispute, it just amounts to propensity evidence. And make no mistake about it, that is what the prosecution is asking this court to do, is sanction propensity evidence. And simply because the prosecution can shoehorn prior bad act evidence into some exception, it does not make it admissible, since it may not bear on a matter at issue in the case. But with that said, if any members of the court disagree with that analysis, and that may be the case, even if this court believes that the signature crime approach is the appropriate approach to this case and a proper theory of admissibility, the prosecution still does not prevail here because the prior bad acts were general in nature insofar as they involved sexual misconduct of some type and the use of an intoxicant. They were not nearly identical as to the charged offense, at least any more nearly identical than they would be to, frankly, almost the majority of acquaintance assaults or date rape situations, where we know that intoxicants almost invariably play a role in those types of assaults. But if you want to get more granular about it, in this case, we have prior allegations, again, 15, 22 years old prior allegations that involve a number of distinctions from the charged offense. I think one of the most astounding ones is the nature of the relationship. You cannot compare the relationship that Mr. Cosby allegedly had with these 5 other women that he did with the complainant. This was an 18-month relationship. This was a relationship that, at least by her own testimony, was built on friendship. They exchanged gifts. They spoke regularly. This notion that he was mentoring her, well, I mean, anybody who comes in contact with Bill Cosby is going to sort of, given who he is, could perceive that he would be a person who's wise and would be able to give you advice. But this is not the scenario where he sought her out or she sought him out for some to advance her acting career or a modeling career. This was a chance encounter. He brought her into his inner circle as a friend, introduced her to people he knew. He traveled to places with her, where New York, Connecticut. So the nature of this relationship was very different. In the 5 prior bad act cases, one woman had not even been invited to Mr. Cosby's home. She just came with a friend, and she was not an actress, and she didn't. This was just a woman that showed up to come socialize with Mr. Cosby with their friend. The other women had met him once or twice. So again, the nature of the relationship, I think, is a marked difference between the prior bad acts. We also have very different sexual type of contact. One of the women, Ms. Lublin, testified that she doesn't recall any sexual contact other than some bizarre behavior where he allegedly stroked her hair. And some women describe, intercourse where other women describe that there was something that didn't involve penetration. So the sexual acts themselves were very different. The nature of the intoxicant was different. In some cases, like Ms. Baker-Kinney, she said, I took the Quaalude. He offered a Quaalude to me, I took it. There's no evidence whatsoever that anybody else was given a Quaalude. Even among the other 4 prior bad act witnesses is in the charged offense. For as much as Quaaludes played a role in this case, from the prosecution's perspective, they will concede. They have no evidence that Mr. Cosby gave Ms. Constant a Quaalude or anybody else, frankly. The only person who speaks about a Quaalude is Ms. Baker-Kinney, who said, he offered me one and I took one.
Counsel,
yes.
This is Justice Todd.
Good morning.
Good morning. Let's assume we accept your argument on prior bad acts, that it was error to introduce it. Could you address the harmless error question? Could this possibly have been harmless error?
It could not have been harmless error, and I think we need only look at the first trial to get our answer to that. It is clear that the prosecution wanted and needed propensity evidence, but they had no right to it. You don't get to make up for weaknesses in your case by bombarding each jury with rank propensity evidence. That's not fair. And frankly, the prosecution's case, the evidence was ample. They didn't need this evidence. They had the complainant's testimony. They had corroboration. They even had an expert who was able to rehabilitate any cross-examination. And with that, the first jury still could not reach a unanimous verdict. And as a result, I don't think that this is a case where there was overwhelming evidence of guilt. And I think we have the benefit of this first trial to tell us that. And yet, the prejudice, again, was extraordinary in this case, and no curative instruction could have solved it. I think the Third Circuit said it best when it commented that when an evidence of this magnitude, yes.
Counsel, this is Justice Doherty again. All right, let me return to the civil deposition because I struggle. It appears that your argument is based upon promissory estoppel, correct?
Correct.
So again, when we're looking at the parties with regard to promissory estoppel and each individual factor, the concern that I have is here, as you indicated in your opening, they're trying to dissect or look at his entire life. And that being that I assume you're implying that he's a celebrity, therefore this is even a harsher look at him. With that in mind, my concern is how are we to accept one of the second prongs of promissory estoppel is justifiable reliance on the inducement when we have to look at this individual. We're dealing with an individual who's knowledgeable of the legal system. He's in entertainment. It's not as if this is his first advancement or use of lawyers. So how is it when you take into consideration the inducement, AKA the Castor press release for which he signed, indicating that Cosby would not be prosecuted for the instant matter of investigation? How is it that we're to find justifiable reliance of an individual who's intellectually, at least legally superior than the average person, based upon his history, as you brought forth in your argument, to really rationalize that he justifiably relied upon refusing the DA's refusal to prosecute, yet provided additional elements of other individuals, not the focus of the initial criminal investigation, and yet affirmatively refused to invoke a Fifth Amendment. I'm struggling with your argument.
My opinion, the reason why I think the justice said he was struggling with Bill is because he know that Bill, is a very educated man, very intelligent. He graduated from different universities with different degrees. And so he felt like, okay, he is a smart person, so he should have known better. So I'm struggling with this because, Bill Cosby is this educated man. And so, just because, a person is educated, we feel that they should know like everything. But no, with celebrities, business owners, you name it, we always, when it comes to legal advice, we always go to our counselors to seek legal advice, and we tend to go on what our legal counselors tell us. We rely on them to give us legal advice. That's just like when you go to you're going to go to a doctor and get the advice from a doctor when you're experiencing certain things with your body, because you're not a doctor. So you can't try to doctor on yourself when you don't know. So you're going to go to a professional like a doctor. Even with your car, if you're not a mechanic, you're going to go to the mechanic and you're going to get that advice from that professional on that. So because a lot of celebrities, they normally seek the advice of their legal counselors when it comes down to the law, and they tend to take that advice and use that advice from their legal counselor when it comes down to law. So once Bill Cosby counselor broke it down, I think that justice understood, where she was coming from on that.
And I understand that, Justice. I think I would disagree with one premise, which is that the assumption that, and with all due respect to Mr. Cosby, that he is particularly savvy about the law, or that he has an understanding of these things. I think high-profile people often rely almost to their detriment on legal advice. They have a lot of legal issues, and they defer many times to their attorneys, who tell them, this is the deal. This is part of the agreement. You will not be prosecuted. Go sit down, cooperate. You cannot invoke your Fifth Amendment right. And he relied on that. The only fair inference is that he did rely on the representations. And that it was done with the assistance of his attorney, who testified. I understood through his criminal counsel, and I understood through the criminal counsel from the district attorney, that this was connected. He had to testify in order to not be prosecuted. So I think to sum up on this point, using absence of mistake as an exception, or excuse me, to use prior bad act evidence to show a mens rea in this case, which is what the prosecution is trying to do, has a number of pitfalls that are identified by Professor Imwinkle-Reed. It's just not. Yes, Your Honor. Thank you very much. I would just point out that prosecuting agencies in this Commonwealth and states across the nation have chipped away at the general prohibition on prior bad act evidence for decades. And with this case, they truly seek to obliterate it. This court should rule to protect the time-cherished rule, not just because it's Bill Cosby or to right a wrong in this case, but because the constitutional guarantees of the presumption of innocence, the burden of proof, and even due process that frame our criminal justice system are at stake. And I thank you all.
Thank you. We'll hear now from the Commonwealth.
And she basically passed out and was unconscious until she woke up 2 days later in her apartment. But the bottom line is that the part of the signature is the entirety of the contact and the conduct between the defendant and these victims. And the
Ms. Jaffe, Tom Saylor, but that conduct you described, the steps, the young women, there's literature that says that's common to 50% of these assaults, thousands of assaults nationwide.
Your Honor, it's the mentor-mentee relationship. It's the fact that the defendant was built trust in his victims because of their mentoring relationship, because of.
I understand that, but you see, if that was the case, I mean, maybe you dispute the literature, but in the briefs, they cite treaties and literature that says that's common to 40 or 50% of these assaults nationwide, that number in the thousands.
Well, perhaps it is true that 50% of sexual assaults are drug-induced sexual assaults.
How can that be a common scheme?
According to what's in the defendant's brief, there's been no evidence at trial as to any statistics, and I would submit that's not part of the trial record, so that shouldn't be considered by this court. But Your Honor, the defendant engaged in a pattern of seeking out young women. He met them through their employment or their career. He offered to mentor most of his victims. There was a built-in level of trust because of his status in the entertainment industry and because he held himself out as a public moralist. The victims were legitimately in the defendant's presence because he invited them to the location within his control under a guise. And each incident occurred, again, in a location within the defendant's control. So he could intoxicate these people, carry out his plan without any interrupted discovery. And then he intoxicated them, waited until they were unconscious or otherwise unable to consent to any sexual assault, and then either sexually assaulted them, or in the case of Lisa Lott Loveland, he engaged in what I would submit as untoward sexual conduct, inviting a young woman to sit in between his legs and then starting to pet and stroke her hair.
Counsel, this is Justice Donahue. What are you describing? A signature? A signature crime? Is that what what you're describing to us? Because
Your Honor, I am.
Let me just.
I apologize.
Asking the question. The assault that took place here, the alleged assault that took place here, took place in the defendant's home after an 18-month relationship with Miss Constand, after meeting her mother, after going on trips with her. I mean, if you're talking about a signature, you better incorporate all of the facts that we have in the case that's on trial with what you are offering as a signature, because frankly, I don't see it.
Your Honor, certain differences. Well, let me say this first. Miss Constand was not the only victim that the defendant had a lengthy relationship with. He had a several years long relationship with Lisa Lott Loveland. He had a relationship with Janice Dickinson. She had been to his apartment in New York prior to the assault, and he sought to mentor her. He also had a relationship with Shalon Lasha. He had spoken to her grandmother on the phone. He had come over to Shalon Lasha's house for dinner. And he also had a relationship with Heidi Thomas. He spoke to her on the phone on numerous occasions. So it's not true that he only had a friendship or relationship with Andrea Constant. And in any event, Your Honor, the actual relationship is just one of many factors to take into consideration in making a determination as to whether or not something is a signature. There are certain distinguishing factors that are inconsequential to whether or not a crime is a signature or whether or not absence of mistake applies. That is, whether or not the defendant was mistaken in assessing Ms. Constant's ability to consent to the sexual assault. And I would submit that the absence of mistake exception, which was the main exception that we proffered this evidence for, has a lesser threshold of admissibility than does the common planner scheme. Whereas the common planner scheme, admittedly, as is pointed out in several opinions from this court, and as the defense points out in his brief, there is, in fact, some conflation between in common planner scheme, for instance, whether or not it's being admitted solely to show a common plan or whether or not it's being admitted for identity purposes.
Can I jump in, counsel? Can I jump in on that for
Sure.
a moment? You've referred to an alleged signature aspect. Identity is not an issue here. So where are you going with this signature allegation? That's number one. And number two, with respect to your repeated argument about absence of mistake, how does that factor in here when Cosby never argued that he made a mistake or that he made an accident or something like that? He argued consent. Can you answer those two questions for me?
Sure, Your Honor. In terms of consent, I would submit that absence of mistake has been admitted in numerous cases or several cases in this Commonwealth to demonstrate an absence of consent, particularly, and I would submit that was the defense here, an absence of consent. And numerous cases, such as Commonwealth versus Tyson, have allowed evidence to come in to show absence of mistake. And in that case, Commonwealth versus Tyson, the defendant was on trial for rape of an unconscious person and a prior bad act of rape of another unconscious person came in, and the Superior Court, sitting en banc, found that that was in fact admissible to establish a lack of consent. And also another case, which was not cited in my brief, Commonwealth versus Tearsguard, that was a 1990 Superior Court case. That was a situation in which the defendant was on trial for raping a teenager, and evidence came in of a prior rape of a teenager to came into absence of mistake to show that he was not mistaken as to whether or not the victim consented. So there are cases in the Commonwealth that allow for absence of mistake to show a lack of consent. And in any event, Your Honor, admitting other evidence to rebut the defense is a staple in Pennsylvania jurisprudence. And the effectiveness of the rebuttal here is enhanced by a distinct pattern of similar crimes indicative of the common conscious design here. For instance, in Commonwealth versus Buck County, that was an opinion of this court with the bathtub drowning case. The defendant was on trial for the murder of his wife, and incidentally, his prior wife died the same way, a bathtub drowning. And in that case, the court found that the evidence was admissible of the prior wife's drowning to, under the absence of mistake exception, to rebut the defendant's contention that the act was the result of a deliberate act. And in Commonwealth versus Hicks, Your Honor, as well, the prior bad act, that was a homicide case, which I'm sure this court was aware of, it was just a few years ago. And in that case, one of the reasons why the uncorroborated testimony of Andrea Constant regarding the lack of consent. And Tyson made clear that this case, or this exact scenario, created a heightened need, noting that if the evidence in that case was excluded, the Commonwealth would have to rely solely on the
Uncorroborated testimony of the victim to counter the defense consent. Now, I will say there was other corroboration of Andrea Constant's testimony, but in terms of consent, there was no other corroboration of her testimony. And in addition, Your Honor, the victim—
Ms. Jaffe, excuse me, but you really, I think, you focus on the lack of consent on the part of the victim, but you're really trying to demonstrate appellant's knowledge of that lack of consent. And that was the argument of the appellant, don't you see, when you use that doctrine, absence of mistake. You want to inject that before the jury to show that the defendant lacked knowledge of the lack of the victim's consent. And I come back again to the problem with that type of testimony, legally and within the literature. That's going to require a jury inference into the appellant's mens rea, which is really what you're focused on. What was the defendant's state of mind? And I'll read you again that the trier of fact can reason from the starting point of the uncharged crime to a conclusion about the mens rea of the charged crime only through an intermediate assumption about the accused's character or propensity. And that's the legal issue that confronts this court in terms of the sanctity of the verdict.
Well, Your Honor, I don't think that's an inference that needs to be taken or adopted, because the whole absence of mistake, it's coming in to show the lack of consent, and the consent—
No, it's coming in to show the mens rea of the defendant with
Your
respect to lack of consent.
I would submit that it's coming in to establish the actus reus because part of the aggravated indecent assault, the actus reus of it is not just the digital penetration, but it's the digital penetration without the victim's consent. That
Did any of these prior victims report, prosecute, or go to court in any way over the incidents?
none of them went to court anyway. In terms of reporting, they did not report the incidents to the authorities for many years afterwards.
Counsel, share with me your position of the use of prior bad acts dating back as far as 37 years ago to 1984 with Heidi Thomas, and how that is probative of current. The question or concern that I have in Pennsylvania jurisprudence, what you're advocating is that 3 decades of an alleged prior bad act is admissible in a trial because there's no ceiling as to the staleness or remoteness. Yet we have to balance that against our own rule of 609 of evidence, in which the use of a conviction is considered stale in the impeachment of a witness, unless there's the other argument, unless it's more probative of. So how is it that we are to digest the use of an alleged act is admissible 14 to 37 years later, yet we don't look as a trial lawyer and as a trial judge? I'm sure you, as a trial lawyer, have been exposed that when you try to introduce a stale conviction, it's objected to and usually sustained. How is it that what you're really asking us to do is to place an alleged prior bad act in being a superior position in its introduction into a trial as opposed to a conviction? I'm really struggling with that position.
Most of the argument today has been whether or not this evidence falls under 404B and is admissible at all. But I think I started this argument an hour ago by asking your worthy opponent about abuse of discretion, and I'm still there to some extent. Did you advocated putting all 19 in? Is that correct? Oh, I lost you.
I'm sorry, can you hear me?
I can't hear you now. You advocated putting all 19 in.
We did.
All right. 150? Is there any point at which we're not trying whether or not the defendant assaulted the victim, but rather trying whether the defendant assaulted one of the other 19 or 18 or 5? And again, I recognize abuse of discretion is a broad standard, but you can still get to the point with evidence that's terribly probative that it's just too much and that this defendant did not have a fair trial.
Well, Your Honor, again, like
Arguendo, it's admissible, but the amount of it is such that the weight was conflated the issue from whether this defendant did this crime to whether he did the other 5 or 18 or 19.
Ruthlessly attack her credibility, and in fact, they did. And we also knew that they were going to call Margot Jackson, who was their super witness.
That has nothing to do with harmless error. So we're going to hear from Mr. Fallon.
Okay, thank you, Your Honor.
May it please the court, my name is Bob Fallon from the Montgomery County DA's office. I'll be addressing defendant's non-prosecution claim, questions of law or questions of law to answer. It is simply, the court does not have to reach the issues of promissory estoppel or any of the other legal or mixed questions that the defendant raises.
Counsel, could I ask you, counsel, pardon me, on that, assuming for the sake of argument that you're right about there being no binding agreement, there would, under any circumstance, not be any argument about the prosecutorial exercise of discretion here. That is to say, as memorialized in Mr. Castor's press release, that a decision was made by the DA's office not to prosecute this defendant. since we're the Supreme Court, this case obviously has implications well beyond this defendant. What is the lesson that emerges from your position in this case regarding the reliability of prosecutorial decisions? What is the implication for the thousands of promises made by prosecutors across the Commonwealth every day or every week? Plea deals, immunity agreements, non-pros agreements, agreements to cooperate with witnesses, et cetera, in return for something, et cetera. If your office's word is not its bond, and we validate your position here, what is the lesson that emerges from beyond this case for all cases going forward in Pennsylvania? You understand my question? Can I just have one brief follow-up on my question? A sitting DA made a decision memorialized in a press release. You don't like that, you being the successor's office, that is. But why does that not bind you as the successor office?
Justice Todd, isn't it fair also to look at Mr. Cosby's reasonable reliance on the agreement he believed he had, based upon the fact that he went forward with the civil deposition and put himself out there for those questions and did not raise any objection at that time or invoke his right to remain silent? Isn't that indicia of reliance on what he believed to be an agreement?
Well, and it backfired on him. That's what happened. There was no, and one important point, and I think Justice Doherty mentioned it earlier. The defendant, by his own allegations, believed he had transactional support. I would respectfully submit has to go. This is an issue for the trial judge, and he properly resolved and denied this claim.
The male DA ended it with, the trial judge has a say in this, and basically he was saying the 7 of you justices do not have anything to say about this case. The trial judge denied it. Y'all have nothing to say. Nothing. He was hotter than this bacon frying in the pan, honey. As I say, hotter than fish grease. Those judges, the justice, they were on them, asking the DAs all these questions and trying to make sense of what they trying to push. And so I see this male DA, he was upset. He knew that these judges was like, we see the BS that y'all pulling. So on that, I rest my case. Y'all please drop your comments down below, and hopefully Bill wins this case, and that way we can move forward in changing the laws on how they bring in evidence.
All you did was get rich out these war crimes. It's a conspiracy. Who's the terrorist? The U.S. government must be the terrorist.